Good afternoon, everybody. My name is Jordan Bates Rogers. I'm the Executive Director of the Arkansas Access to Justice Commission and Foundation, and we're so excited that you were interested in learning about defending folks who are facing eviction in Arkansas. We know that COVID-19 and the recession has led to a lot of tenants facing extreme hardship and potential eviction. The CDC moratorium, there's still a lot of challenges. So we're really thankful that Kendall Llewellyn, who is the Housing Work Group Leader at the Center for Arkansas Legal Services, and Jason Auer, who is the Housing Work Group Leader at Legal Aid of Arkansas, are going to be talking with us today about defenses to evictions in Arkansas and the state of the law on eviction and housing in Arkansas. A couple of housekeeping matters that I want to cover before we get started. If you weren't here earlier when we were covering this, the CLE form for today is at arkansasjustice.org/eviction. That link is in your chat. You do have to attend the full hour and a half to claim CLE credit, and the Office of Professional Programs does require us to monitor your so the software will monitor how long you're here. We also have 3 polls today, 2 or 3 that will launch that you do have to answer in order to get CLE credit. Again, that's one of the conditions of the Office of Professional Program when we do webinars. So I think that's all of the logistics. We're going to go ahead and launch the first poll to answer that, and then we'll let Kendall and Jason get started. So you should see a poll on your screen now, and you'll have about 2 minutes to answer that. It looks like someone is asking, will they be able to get a copy of the PowerPoint? Yes, all materials from today's presentation are available at arkansasjustice.org/eviction. is in the chat, and we hope you'll use the Q&A during today's presentation to ask questions as well. It looks like we have about 89% of people who have voted in the poll. Give just a little bit longer before we close that one out. Okay, we're going to go ahead and close that first poll. Don't worry, if you didn't answer this one, you still have a couple more chances to verify your attendance, so don't worry about that. And I'm going to share the results now. So it looks like about 84% of folks who are attending today are lawyers. We've got a few judges, some paralegals, social workers, and some members of the public. We're so glad to have all of you. And Jason, I'm going to turn it over to you now.
All right, thank you, Jordan. My name is Jason Auer. I am the Housing Work Group Leader and Fair Housing Project Director at Legal Aid of Arkansas. I've been with Legal Aid of Arkansas going on my 10th year now, and I handle a lot of different types of cases, but mostly eviction defense, foreclosure defense, and fair housing and housing discrimination cases. Kendall Llewellyn is with us today. Kendall, you want to introduce yourself?
Sure. I'm Jason's counterpart at the Center for Arkansas Legal Services, where I lead our housing law practice group. We handle similar case types for CALs, and we're a nonprofit law firm. We represent tenants and homeowners who are trying to keep their homes through civil cases, and occasionally in a criminal case if it's a failure to vacate.
All right, thank you, Kendall. And Legal Aid of Arkansas and the Center for Arkansas Legal Services are your 2 private, nonprofit law firms that operate in the state. We handle the gamut of civil legal cases, from family law to public benefits law to consumer law, and then what Kendall and I do, housing law. I just want to give a kind of brief statement about what we're doing here today. Because of the COVID-19 pandemic and the economic situation that has arisen from that, both CALs and Legal Aid are seeing a significant uptick in landlord, tenant, and eviction cases. We expect that to only get worse when the federal moratorium expires. It was set to expire December 31st. That got extended to January 31st. We do not know if that will be extended, or if it is, how long the extension will be. Don't expect it really to be extended at this point. So that could increase the number of eviction cases even more. So what we're doing here today, Kendall and I are going to give you, as members of the private bar, a crash course in landlord, tenant, and eviction defense, with the goal being that if we get overrun by these cases, and it's already starting, that we can maybe do some of these referrals to our private attorney partners to help handle these cases. So that's what we're doing. We're going to try to give you a very practical and pragmatic tour through landlord tenant law and eviction defense. And with that, we'll go ahead and get started. Oh, there's our contact information, sorry. All right, an overview of the presentation. We're going to start with a little bit of a background of Arkansas landlord tenant law. We'll then move into eviction. Specifically, we will go through unlawful detainer, which is the main eviction procedure in Arkansas in great detail. We'll also touch on some other types of evictions that happen around the state. Kendall will talk to you about defenses that you can make to these types of cases, as well as counterclaims. We'll also go through some resources, both for learning how to do these cases and also for rental assistance, helping people get the money to pay their rent. There's some opportunities for that going on right now. And then we'll kind of close with pro bono opportunities and explain a little bit of what you can do if you want to help with these types of cases. All right, some background on Arkansas landlord tenant law. Most of you guys probably know that Arkansas is recognized as not having very friendly law for tenants. There's a Vice News piece that aired a few years ago that called Arkansas the worst place to rent in America. Human Rights Watch, which is the other report you see down there at the bottom of your screen, actually came and did an analysis of Arkansas law. Human Rights Watch is an international human rights watchdog organization that, you know, will go to places like Sudan and document human rights abuses. Well, they came here and looked at our landlord tenant law and wrote a fairly scathing report about it. Why is Arkansas recognized as a tough place for tenants? Couple reasons. Firstly, Arkansas is the only state in the country to criminalize non-payment of rent, and we'll talk about that more in a little bit. We're also known as the only state that has no implied warranty of habitability in lease contracts. That means that there are no statutory or state law imposed minimum standards for keeping up a rental house to any type of standard beyond what is required under local codes, which vary greatly from jurisdiction to jurisdiction here across the state. Also in 2007, our Arkansas legislature, the General Assembly, enacted the Arkansas Residential Landlord Tenant Act. The Residential Landlord Tenant Act is it was derived from the Model Residential Landlord Tenant Act, which is a model law that's been enacted in a lot of different states, except Arkansas heavily modified it, took out a lot of the tenant protections, lopped on an eviction procedure that is not there in the Model Act, and enacted that. So that has not been helpful to tenants as well. All right, so we'll start kind of from the very basics here. What is a tenancy? Tenancy is a possessory estate in land, leasehold estate it's called if you look in the old books. There are other possessory estates in land one can have, the most common being a fee simple if you own land. But this is a leasehold estate. It is a right to possession that is granted to a tenant by a landlord. The right of possession is a constitutionally protected property right. And that means that in order to take that property right away from the tenant, you have to go through due process. Tenancies are governed by a contract called the lease agreement. The lease agreement is a series of promises that are made between the landlord and tenant. So rights and obligations of the tenancy and the rules of the tenancy are going to be contained in the lease agreement. Lease agreements can be oral or written, but there's always a lease agreement. Sometimes you hear even attorneys or especially landlords or tenants say, well, we don't have a lease agreement. We're just, there on an oral agreement. That's fine. There is always going to be a lease agreement, whether that's oral or written. Obviously, if it's written, it's a lot easier to deal with in court because the parties are going to have a much more clear understanding of what the rights and obligations are than they would in an oral lease agreement. But either way, there will be a lease agreement. If there's an oral lease agreement, it has to be a year or shorter. That's, of course, the statute of frauds. Written lease agreements can really be any amount of time, a reasonable amount of time anyway. Tenancies are distinguished from other possessory interests in land, such as a lodging agreement. Lodging agreement is like a motel type situation. Contract purchaser in possession is different as well. That's where you've got a land sale contract going on where there's a contract, and at the end of it, the seller is supposed to transfer the buyer actual ownership interest in the property. And then, of course, a mortgagee, where somebody buys a house and is there under a mortgage. I'll add another one that we see a lot is a licensee. A licensee is just a person who's on someone else's property with just by permission. So that's a guest, something like that. And there are a lot of situations crop up where you have to try to figure out whether a person is actually a tenant or whether they're simply a guest. The main thing you look at is whether they're paying rent, but they don't necessarily have to be paying rent. There can be any type of compensation type agreement between the landlord and the tenant. So there are factors you look at to determine whether a person is a licensee or a tenant. If they're a licensee and permission is revoked for them to be there, then at that point they become a trespasser. A tenant does not become a trespasser if they overstay their lease. They become what's called a holdover, and they have certain rights that are dealt with through our Arkansas landlord tenant law and eviction statutes, whereas a trespasser can simply be dragged out by the police, so to speak. All right, Kendall, do you have anything you want to add so far?
No, I will let you know if I do.
All right. All right, lease agreement. Lease agreement, like I said, there's always going to be a lease agreement. It is the contract between the landlord and the tenant that sets out the rules for the tenancy. Very important. If you are going to handle landlord-tenant cases from either side, you want to get a copy of the lease agreement because that is where 90% of what you are looking for is going to come from. So if your landlord is wanting to evict somebody, there are only two reasons for that, really. One is that they have overstayed at the end of the lease and are holding over. So it's a 1-year lease. They're there for 1 year and 1 day, and there's been no agreement to extend the lease. They're holding over. And the other one is for a breach of the lease agreement. So you're going to have to look at the lease agreement to figure out if there is actually a breach. There is kind of a third category people can fall into where they're violating certain state landlord-tenant laws and may be subject to eviction, even if they've not breached the technical language of the lease agreement. But for the most part, most of your evictions are going to be based on breaches of the lease, most commonly non-payment of rent, but could be any material term in the lease agreement. Most courts are going to hold that the terms in the lease agreement govern. There are some illegal terms that can be in a lease agreement that you have to look out for, such as penalty clauses, which are clauses to pay where a breach of the contract causes the tenant or the landlord in some cases to pay an amount of money that is not in compliance with Arkansas law regarding liquidated damages. Attempts to forego statutory eviction procedures. That's the Gorman v. Ratliff case we're going to talk about later, where the lease purports to authorize self-help eviction. Those are going to be held not to be legal. And I will also say any attempts to waive state or federal civil rights laws are not going to work as well. And you see that sometimes, and that should throw up an immediate red flag for you. All right, so those are your lease agreement obligations, and those, we can't really list out in full because they differ from lease to lease. It's just very important that if you're going to take these cases, you get a copy of the lease right off the bat. When someone calls legal aid, that's the first thing we ask for. If they've got a landlord-tenant issue, send us your lease because we have to look at that. Beyond the lease, there are some tenant obligations that are within the Arkansas Residential Landlord Tenant Act. So this is going to be that 2007 Act I talked about, put some obligations on the tenant through state law, and that citation is 1817-601 if you want to look at these. The obligations are to pay rent on time, obviously, to keep the unit reasonably safe, clean, dispose of ashes, garbage, and other waste. So keep the place clean, keep plumbing fixtures working and reasonably clean, not to destroy or damage the property, and not to disturb other tenants' rights to enjoyment of the property. So those, even if they're not in the lease, they are violations. If the tenant's not complying with these, they are violations of state law, and will put tenants in violation of the Arkansas Residential Landlord Tenant Act. Move on to landlords' obligations. It is a considerably shorter list. Landlords have to comply with Arkansas security deposit law, which I believe is at 1816-301. The security deposit in Arkansas, we're not going to talk about as extensively as we might, but the basic rule with a security deposit is, well, there are a couple basic rules. First, a security deposit on the front end is not supposed to exceed 2 months' rent. So if the monthly rent is $500, your security deposit's not supposed to be any more than $1,000. The end of the tenancy, the landlord is supposed to give the security deposit back to the tenant, and they're supposed to do that within 60 days. And if they don't want to give the security deposit back, want to make some type of lawful deduction from the security deposit, they're supposed to give the tenant an itemized receipt, usually called a security deposit disposition, showing how that money was spent. Security deposit lawful deductions are going to be for normal wear, or going to be for damages beyond normal wear and tear. So that's any type of damage to the property that goes beyond what would be normal for people just living there. And the other one is the security deposit can be withheld to cover unpaid rent. Landlords are supposed to comply with property maintenance codes, as are any owners of property in locations where there are property maintenance codes, which is not everywhere in Arkansas. Here in Little Rock, there's a pretty robust system of city property maintenance codes, and there are in a few other cities across the state, but some more rural locations don't have any codes at all. Some of them have very simple codes that don't cover very much. So that's going to differ from jurisdiction to jurisdiction. Also, keep in mind that there's no private right of action for tenants to enforce city codes. City codes are going to be enforced really through a criminal process between the city and the property owner. So while tenants can make complaints, they can't really enforce those in civil court. Comply with terms of federal funding. We'll talk about that here in a second. That is a giant rabbit hole. But what that means is if the landlord is receiving funding from the government, typically this is going to come through the U.S. Department of Housing and Urban Development. That can also come through rural development funding. These are all going to come with a system of federal regulations, and each program is going to have its own set of federal regulations, and those have to be complied with as well. So we'll give some examples of where things will be different if you're dealing with federal funding. If you are dealing with federal funding, the first thing you have to do is figure out what that funding is and figure out what set of regulations apply, so you can then go back and see what extra obligations are going to be added to the landlord for having accepted that federal funding. Abide by civil rights laws. This is going to be, there are several civil rights laws that you have to abide by as a landlord. The biggest one and the one that kind of weighs most in this type of situation is the Federal Fair Housing Act. There's also a State Fair Housing Act that's substantially similar. We'll cover a little bit of fair housing later on in the lecture. And then comply with any federal, state, or local eviction moratoria. Kendall is going to give you a good discussion about the current Centers for Disease Control moratoria that we're operating under right now, a little bit later in the lecture. Subsidized housing. Just kind of talked about that one a minute ago, but that is going to be where you are receiving money from the government as a landlord. So common subsidized housing programs are public housing, which is housing that is owned by a public housing authority. Section 8 Housing Choice Voucher Program, which is your vouchers where HUD gives vouchers to tenants through a housing authority, and they're able to use those vouchers out in the community to offset rent. There are other HUD-funded subsidized housing programs, such as the project-based Section 8 program. USDA Rural Development provides a kind of government-owned public housing for rural communities. So all of these programs are out there, and there are many more, and each one has its own scheme of federal regulations. And the most important thing I can tell you about that is if you decide, or if you figure out that the property that you are dealing with receives a federal housing subsidy, you need to figure out what that subsidy is and what set of regulations apply. How do you know if you're dealing with federally subsidized housing? Sometimes the lease will say, sometimes the lease will reference HUD or USDA. There are some model leases that are out there for use for these programs. But the big thing you're going to look at is whether rent is reduced below market value. If you if a tenant comes to you and you look at their rent and they're paying $150 a month in rent for a normal apartment, then there's an excellent chance what you're dealing with is some type of federal subsidy. These regulations typically go beyond Arkansas landlord tenant law and what's required to either terminate a lease at the end of it or to evict someone. There are different procedures that have to be followed. There's an excellent Arkansas Supreme Court case called Dial versus Star City Housing Authority that basically said that when you're dealing with one of these schemes of regulations, you have to strictly follow those regulations or your unlawful detainer action is going to be subject to dismissal. So these subsidized housing regulations can be very powerful tools for the tenants advocate in these types of cases. All right.
Jason, if you have a minute, we're running good on time, and it looks like there are quite a few questions in the Q&A. Maybe we could go through a few of those.
Sure, let's hit it.
Okay, so it looks like Darren Williams breached agreement for non-payment. They're still in possession of the property, and the landlord sells to a new rental property. New owners want to move to evict. It looks like his question got split up. Can the new owner use non-payment to the old owner as a basis for eviction?
Yeah, so this is a good question. When you have a situation where you have a tenant who has a lease and is living in a property, and the owner of that property sells to a new owner, then that lease runs with the land, and the new owner becomes the landlord. So the new owner is going to take pursuant to the lease agreement that is on the property. Now, that is, unless there's some type of new agreement that comes in, it's going to be the same lease, same rent, same terms. So I think, yes, if someone takes pursuant to a lease and there's been a violation of that lease, then the new owner could enforce the violation of that lease.
Okay, it looks like Kevin has a question. If the landlord does, such as a person leasing land for the purpose of, let's see, a residence in an RV, what impact would that have?
Sorry, you broke up a little bit there, Jordan. What?
So it looks like Kevin is asking if the landlord does not provide a building, such as a person leasing land for the purpose of a residence in an RV, what impact would that have?
We see these a lot. They're called lot leases. They're going to work generally the same. You're going to have a lease agreement with a set of rights and obligations, and if the tenant breaches those obligations, or the landlord breaches those obligations, they're going to be liable for that.
And John has a question. Fee of $10 or more per day be considered an unlawful penalty?
Oh, that's an interesting one. Potentially, if there is no end to it, those fees that just kind of keep adding up day after day after day may eventually run afoul of Arkansas usury laws, which are in the Arkansas Constitution. So very possible, and that is something that if you have one of those, you're going to want to investigate that and see exactly how that fee works and dig into it.
I'm trying to find one that was in the chat. It looks like somebody had asked if security deposits have to be held in a segregated account by the landlord, sort of like in an IOLTA account.
I'm not aware that that's a requirement. You know, if at the end of the tenancy the landlord does not have the security and cannot provide it back pursuant to law, then the tenant can bring statutory action under Arkansas law to recover that. And if it is found, or if the judge holds that the security deposit was being held in bad faith or withheld in bad faith, then the tenant can actually be awarded twice the amount of the security deposit.
I've got one more for you, and then we're going to pause because we have a lot of questions, and I know you have more material to cover. Do tenant and landlord obligations under statute exist in a lease agreement, or do lease terms supersede? And that's from Howard.
It depends on what it is. You know, most of the time, the courts are going to hold what's in the parties' lease agreement is going to be what they're going to go by, and unless it's something I think that's just like manifestly unfair, then I think they're going to go by what's in the lease agreement. Kendall, do you agree with that one?
Yeah, I was thinking that if the lease agreement requires the tenant to waive some of their statutory rights, you know, the tenant might have a good argument that those provisions are unconscionable and shouldn't be enforced.
Right,
but people generally go by the lease.
Keep those questions coming in the Q&A, and there's a like button beside each question. So if you see a question you want us to answer, like it, and it'll push it to the top the next time we stop to answer questions.
All right. We're going to move into the second part of this fun now. We're going to talk about evictions in Arkansas. So evictions, these are legal processes that lawfully end tenancies and allow the landlord to remove the tenant from the dwelling by court order, or at least that's what most of these are supposed to be. Well, let me go back one. So there are 3 types of evictions really in Arkansas, or 2 types. It just really depends on how you want to define eviction. The most common eviction in Arkansas that most people use, most attorneys, 90% of what you see filed here in the state is going to be an unlawful detainer eviction case, which is a lawsuit filed in circuit court. We'll talk about that here in just a second. There's also that eviction lawsuit, type of eviction lawsuit I was talking about earlier, that is in the Arkansas Residential Landlord Tenant Act. We'll discuss that very briefly. There are not too many of those being filed around the states, or the state, for various reasons. One big reason, really. Criminal eviction, which is the criminal sanction for failure to pay rent. We'll talk about that shortly. And then self-help eviction, which is an eviction that you see fairly commonly, but is not legal. Unlawful detainer. So this is the most common type of eviction in Arkansas. This is going to be found at Arkansas Code 1860-301 and through 309, I believe, 311 maybe. This is going to be your most common type of eviction, and we'll discuss kind of how it works and what what it provides for and some issues with it, and then Kendall will talk about how to defend it here in a minute. So how does it start? It is going to start with an eviction notice. So if the landlord says there has been some type of breach of the lease agreement, then the landlord is going to give an eviction notice. How long does the notice have to be? Well, for non-payment of rent, it's very clear. It's a 3-day notice. For any type of breach of the lease agreement other than non-payment of rent, it is not as clear. It does not say how long the notice period has to be. There is a provision in the Arkansas Residential Landlord Tenant Act that says that for notices or for breaches that are not non-payment of rent that can be cured, that the landlord is supposed to give 14 days notice with an opportunity to cure that. So, you know, if they're evicting for an unauthorized occupant, the landlord is supposed to give 14 days notice that says, hey, you have an unauthorized occupant. And if the tenant gets rid of the occupant within the 14 days, then that should take care of it. It is unclear whether that code provision applies to unlawful detainer. I think it probably does, because there's nothing more specific in the unlawful detainer statute itself. So that's the notice provision. The notice must be given in a way reasonably calculated to get to the tenant. That is a U.S. Supreme Court case, Green v. Lindsay. You know, can be given to the tenant personally, obviously, can be mailed to the tenant. You know, probably it's reasonable if you're communicating with the tenant through email. You may be able to email it to the tenant, but it has to be in a way reasonably calculated to get to the tenant. You can't just throw it in the ditch in front of the tenant's house, or do something that, you know, turn it into a paper airplane and fly it over their land. That kind of stuff is not going to work. Once the tenant gets the notice, then they have the notice period to vacate. So in the non-payment of rent instance, they've got that 3 days where they can vacate, or they can bring their rent current, but they have to do one of those things. I will mention the CARES Act. The CARES Act was the first coronavirus relief act that was passed last summer. That one actually created a different notice requirement for properties that were either federally subsidized or had a federally backed mortgage. And Kendall will talk about that in a minute, but it's really hard to figure out as a tenants advocate whether a property has a federally backed mortgage or not. But if it does, then there is actually a 30-day notice requirement for non-payment evictions. So it gets a little confusing there, but Kendall will clear it up for us, hopefully. So that's the first step. Landlord determines there's a breach of the lease agreement and gives a notice. The tenant, if they stay beyond the notice period, then the next step is to file a lawsuit in circuit court. There's a $165 or $167 filing fee plus service costs. Obviously, you guys know how to file lawsuits. So what does the lawsuit look like? What will the tenant receive? The tenant's going to receive a few different documents when they get the lawsuit. And the lawsuit's going to be served the same way as any other lawsuit pursuant to Rule 4 of the Arkansas Rules of Civil Procedure. Tenant's going to get a summons. The summons should note the 5-day requirement, which I will talk about in a minute. There's going to be a complaint and unlawful detainer, which is going to look like any other complaint. There's also going to be a document called a Notice of Intent to Issue a Writ of Possession. This specific language comes from the Arkansas Code. There's actually the specific language that you are supposed to put into the Notice of Intent. If there is no Notice of Intent to Issue Writ of Possession, then the landlord can't get the writ from the clerk in 5 days, which is the procedure I'll talk about here in a second. But that's very important that that notice of intent be there, or else it's going to change the time frame of the lawsuit drastically. There has to be an affidavit, either signed by the landlord or other credible person, the statute says, that knows about the breach of the lease agreement and can swear to it. That affidavit is in addition to the complaint and is usually attached to the complaint. Sometimes you see this affidavit signed by the attorney bringing the complaint. I would caution people not to do that. because you are swearing to the facts of the case at that point as the attorney, which arguably could turn you into a fact witness. So that needs to be signed by the landlord or somebody associated with the landlord that's able to swear to the breach of contract. If the affidavit's not there, it probably means the lawsuit is defunct and subject to dismissal. There's also going to be attached to the complaint, the lease, and the eviction notice. Those are required documents under Arkansas Rule of Civil Procedure 10D if the allegations in the complaint are relying on a breach of the lease agreement. Obviously, the lease agreement has to be attached, just like any other breach of contract case. And then that eviction notice, because it's required by statute, is also a document that needs to be attached pursuant to 10D. If those documents are not attached, then you've got a pretty good argument that the landlord has failed to state a claim under the Unlawful Detainer statute. Once the tenant is served with the Unlawful Detainer statute, they are under a fairly quick timeline to respond. The Arkansas Unlawful Detainer statute gives a tenant 5 days, excluding Sundays and legal holidays, to file a written objection to the lawsuit with the circuit clerk. The tenant can file that objection. If the tenant files an objection, then things kind of slow down. But if the tenant does not file an objection within that 5 days, then the clerk is actually authorized to issue a writ of possession, and the writ of possession is the document or order that actually allows law enforcement to come out and forcibly evict the tenant. When the tenant files the objection, there is also a requirement under the Unlawful Detainer statute that the tenant must deposit any rent owed into the court's registry. So you may be thinking, well, how do we know how much rent is owed? What if the complaint doesn't say? What if the amount of rent owed is disputed? Well, that's a big problem with the Unlawful Detainer statute. There's no real mechanism for the court to figure out what amount of rent is owed and if rent is owed at all, and whether the tenant can test the rent owed prior to or when the objection is filed. And what the statute actually says is if that money is not deposited into the rent, then the court can issue a writ of possession just based on the fact that the rent has not been paid into the registry. That's a very problematic, probably unconstitutional requirement that is under the law. The tenant must also continue paying rent into the registry during the pendency of the case. That is not as problematic. But you want to be aware that if you're representing a tenant, you tell them that they need to make their rent payments into the registry of the court during the pendency of the case and not directly to their landlord. It's very important. Courts and judges and clerks vary widely on whether they enforce this registry requirement at all and how it's enforced. Some courts are very strict, and if that initial deposit is not made, the court will go ahead and order the clerk to issue a writ of possession. Some courts out there ignore the registry requirement entirely. It really just depends on the judge and the jurisdiction that you are in. The tenant does not properly object within the 5 days, so if they just don't file anything, then the clerk will automatically issue the writ of possession. If they do file a response, then the matter will be set for a hearing before the circuit judge, and that's called a possession hearing, and we'll talk about the requirements of that here in just a second. The tenant, so the objection just simply has to say that the tenant has some basis to object to the landlord getting possession. If they file that, it can be a very short pleading in 5 days. That's what stops that process where the clerk can just issue the writ of possession in 5 days. The tenant then has the normal 30 days, or doesn't then have it, but they have 30 days from the date they're served to file a formal answer admitting and denying all the allegations in the complaint like any other lawsuit. All right, so now we're gonna assume the tenant has properly filed the objection and paid whatever they needed to pay into the registry, and now there's going to be a hearing on the matter. Unlawful detainer is what's called a bifurcated process. That means there are 2 hearings under the law. This is very clear in the statute and also through Arkansas Supreme Court precedent that these two hearings are required. The first hearing is a hearing on possession only. All right, so that means the court is not going to deal with damages or background or security deposits or anything like that. They're simply going to deal with the issue of possession. And there'll be a hearing. This hearing is usually set pretty quickly, within a couple weeks in most jurisdictions, a little bit longer in some other jurisdictions where they don't have court as often. The possession hearing, what's going on there is it's kind of like a preliminary hearing, and the landlord has the opportunity to show that they are likely to win on the merits, and if of a full hearing. And if the landlord is able to make that showing that they're likely to win on the merits, then at that point, the court can issue the writ of possession and give possession back to the landlord. Now, the statute says at the time the court makes the ruling that it's going to give possession back to the landlord after that preliminary hearing, the landlord is supposed to post adequate security. The statute says, I've never seen that one enforced where the court makes the landlord post any security whatsoever. For example, it's analogous to the Replevin statute where, if you were suing because you think somebody has wrongfully taken your toaster oven, the court would make you post security. But for a house, they typically do not, even though the statute says that they should. If the tenant loses the possession hearing, then the court will issue the writ of possession or direct the clerk to issue the writ of possession. The tenant can maintain possession even after they lose a possession hearing if they post adequate security. That's 1860-307E. That does come up sometimes, not usually in non-payment of rent cases, but sometimes where the breach of lease is something else, or if there is a defense that we're wanting to make and take to a full hearing. We will sometimes ask the court to set security pursuant to 1860-307E, and I have seen that done. Many landlords at the point after the possession hearing, when they get the writ issued, will dismiss the case and not go to the second hearing. The second hearing is a hearing on damages. So this is going to be where the court can award back rent or deal with issues regarding security deposit or deal with the tenant's counterclaims or anything like that. That is supposed to be reserved for that second final hearing. That is not preliminary. It's going to be set on the court's normal docket. And those types of issues are dealt with. Then sometimes landlords elect not to pursue that and don't go to that hearing and will simply dismiss their case under Rule 41 after they get the writ of possession, and that's fine. They can do that. If they want to pursue damages, and they are entitled to under the unlawful detainer statute, they can get actual damages, which are going to be, rent, damage to the apartment, anything like that is going to be actual damages. There are also liquidated damages under the unlawful detainer statute, which vary greatly depending on whether it's unlawful detainer of a residential property or an unlawful detainer of commercial property. Costs, potentially attorney's fees. There is some conflicting law on whether attorney's fees can be awarded under an unlawful detainer, but they usually are. If the tenant wins, the tenant can get damages if they were dispossessed. So if they have been put out of the property earlier in the process, they can get damages for that. If they had to go live in a hotel or had to live somewhere else. They can also get what's called a writ of restitution, which is the opposite of a writ of possession, which is a court order that allows the sheriff to actually restore tenants to the property that they were wrongfully dispossessed of. In my 10 years of doing this, I've seen that happen once, but it is out there and it is in the law. Final hearing can be tried to a jury if you've got a really compelling case and you want a jury to hear it. That is perfectly appropriate under the unlawful detainer statute. Execution of a writ of possession. So this is what happens if that writ has been issued. The writ is going to be an order that's going to be given from the clerk to the sheriff. The sheriff will then take the writ and serve it to the tenant. And the writ gives the tenant 24 hours to vacate. So usually what will happen is the sheriff will come out, knock on the door, hand the tenant the rent and say, I'll be back here tomorrow. And if you're still here, then I'm going to have to throw you out. We get a lot of calls from tenants who say, hey, I just got a 24-hour eviction notice from the sheriff. And what they're usually talking about is the writ of possession at that point. At that point, it's really too late to do anything for them about possession. You can still look at their lawsuit. You can still help them file an answer in most cases. If there are counterclaims to be made, you can still do that. But it's going to be tough to challenge possession at that point unless there was some type of procedural defect. After 24 hours, sheriff can come back and throw the people out and change the locks. If there are possessions left on the tenant's possessions that are left on the property, what the statute says is that the landlord is supposed to lock them up in a public storage facility or some other reasonable place, and then the court will deal with disposition of those assets at the final hearing. Can order them sold to satisfy a judgment, for example, or can order them given back to the tenant, as the case may be. Really what you want to advise your tenants, though, is if they think the sheriff's going to come and evict them, they need to get all their valuable stuff out of there. Because if they don't, then it can get tied up in the court process. All right, so that's unlawful detainer. Jordan, do we want to take a brief break and talk about or see if there are any questions pertaining specifically to unlawful detainer?
No, we're running short on time. I think we'll have to keep going.
All right, let's go. All right, the second type of eviction case in Arkansas is the Arkansas Residential Landlord Tenant Act eviction. This one is not heavily used. It's at 1817-901. It's part of the Residential Landlord Tenant Act. It is rarely used due to jurisdictional issues. Specifically, the Arkansas Supreme Court has not conferred on district courts, which is where the statute says these are supposed to be filed, subject matter jurisdiction to hear these types of claims. Some courts hear them anyway, but it's pretty well accepted that there is not currently jurisdiction from the Supreme Court to the district courts to hear these. So that's kind of where they stand right now. It's a slightly different process that I'm not going to go through in detail, but it also starts with a notice. There's the opportunity to cure. Once the complaint is served, it usually comes with an order to vacate or show cause within 10 days. The tenant can show up and contest the grounds for the eviction in the district court. And then at that point, the district court is authorized to issue a writ of possession under the statute, but once again, not necessarily under Supreme Court authority. Eviction type number 3 is failure to vacate or criminal eviction. That's our criminal sanction for non-payment of rent in Arkansas. As we said earlier, Arkansas is the only state that criminalizes non-payment of rent in this way. It's the only it's the only state with a law that is anything like this. The way that one works, and it's only used in a few different counties in Arkansas, if a tenant fails to pay rent, landlord can give a 10-day notice. If the tenant stays beyond that 10-day notice, then the landlord can go and make an affidavit with the local prosecutor. Prosecutor will then have the sheriff serve the tenant with something that looks like a traffic ticket. And at that point, they start accruing a $1 to $25 a day fine as determined by the court. They're going to have to show up on a court date on like traffic day at the district court and plead guilty or not guilty. And then the matter will be set for a hearing. All that time, this fine is escalating and escalating at $1 to $25 a day. There is no writ of possession that's authorized under this statute, so the district court cannot order the sheriff to go out and forcibly remove somebody through a writ process like under the civil eviction processes. But it kind of works by coercion because you've got this ever escalating fine that's determined mostly by how long it takes the case to be heard in court. So we say kind of the vagaries of the criminal justice process, how long it is between the arraignment and the trial and any continuances, all that time the fine's just building up. So that's the criminal eviction statute. Self-help eviction, last type, that is changing the locks, shutting off the utilities, taking off doors, taking out windows. Any of this stuff, if done without a court order, is going to be illegal. Certainly threatening tenants. We've had a situation where a landlord ran tenants off at gunpoint. These types of things are illegal. Tenants can bring claims under the Forcible Entry and Detainer statute, which is the kind of other side of the unlawful detainer statute. And if this happens, tenants can get damages, those same liquidated damages I discussed earlier, also potential tort remedies, criminal sanctions, depending on what the case may be. And then Gorman versus Ratliff is your Arkansas Supreme Court case that says that even if it's authorized in the lease, self-help eviction is illegal under Arkansas law. And
Okay, this is a point where we need to launch another poll to verify attendance. So if you missed the first poll, this is your chance to verify your attendance. And you should be seeing that now. And while that poll is running, I made a mistake and left off part of Darren Williams' question earlier. Sorry about that, Darren. It looks like he's saying the second part of his question was, can a previous, let me make sure he had a question about the property is sold and the tenant was behind on rent. Can the previous owner go after, or I think he means can the new owner go after the tenant for the back rent owed during the previous owner's ownership? There was no agreement regarding back debt for the non-paying tenant. Hopefully I managed to get that conveyed correctly.
I think there'd have to be some agreement between the new owner and the previous owner to, be a successor in interest to that account. So potentially, it depends would be my answer, the standard legal answer on that one.
Okay, it looks like 90% of folks have voted attorney, and you are attending and you want CLE credit, please, please, please answer this. We want to make sure you get CLE credit, but we do have to follow the rules, which means you have to attend the entire presentation and you have to interact with at least one of the polls for us to be able to verify attendance for you. So I'll give you just a few more seconds to vote. There will be one more poll, so if you missed this one, you still get a chance to verify your attendance. Okay, we're gonna have to end this one. And we'll share the results quickly. So the question was, which eviction methods are used in your area of the state? It looks like by far unlawful detainer, 77% of folks said that is used in their area. Criminal eviction is also very, very common. It looks like 31% of folks said that criminal eviction is something that tenants can face in their area. 29% are using the Arkansas Residential Landlord Tenant Act. And again, really sadly, 20% of people are seeing illegal self-help evictions in their area. Okay, Kendall, I will turn it over to you.
Thank you, Jordan. So I'm going to go over some common defenses that can be raised in a residential eviction. And one second, I'm having a difficulty with my slides. Here we go. Any defense that would serve, as a defense in a civil eviction can be raised in a failure to vacate or criminal eviction case as well. Some of these are going to be specific to like an ARTLA or 2007 Act eviction, but here's a general overview, and we're going to go through all of these in quite a bit more detail in a moment. I'm sure that most of you have heard of the federal eviction moratorium or the order from the U.S. Centers for Disease Control and Prevention to temporarily halt evictions for non-payment of rent. So in September, this order went into effect from the CDC, and essentially in a residential landlord-tenant relationship, a landlord or someone with a legal right to pursue an eviction cannot evict any covered person from that residential property as long as this order is in effect. So that raises some questions. What is an eviction? What is a covered person? How long is the order in effect? Eviction is defined very broadly as any action to remove or cause the removal of a covered person. And because it is defined so broadly, I believe, and many others believe, that this defense can be raised at any point in the eviction process. And many times it can be raised even after a writ of possession has been issued, as long as the tenant remains in possession of the home. However, judges are going to interpret that in their own discretion. A tenant is a covered person as soon as they have signed this declaration or form provided by the CDC and given it to their landlord. It does not have to be served through any formal means. If I was advising a tenant, I would advise them to do it in person with a witness present, a friend or family member, or through email so that there is some sort of record that the landlord received it. The declaration does have to be signed under penalty of perjury, and there are some basic income requirements. Most people who are facing eviction for non-payment of rent are going to meet those. An individual has to make less than $99,000 a year for it to apply. And there are a couple other ways for someone to meet those requirements as well. But they have to make a good faith effort to get government rental assistance. So they need to be calling their local nonprofits that administer rental assistance money from the government. They need to be calling their local housing authority, trying to get on waiting lists for income-based housing. They need to make a good faith effort to pay their rent. But if they can't, because they've lost income or work, or they have extraordinary medical expenses, this is here to help them. They still have to make partial payments as their income allows. And, the rent is not forgiven. So this isn't really a long-term solution for most people. They also have to, swear in their declaration that they would be homeless, or that they would have to, move into another household if they were evicted. Congress has extended this to January 31st right now, and there is a big open question of what's going to happen after that date. However, I'm not a fortune teller. I think it is fairly likely that the Biden administration or Congress will put some other sort of eviction moratorium in place towards the end of January. But we're just going to have to wait and see what happens with that. A best practice for a tenant or someone representing a tenant is to file this declaration in their case. I would recommend that they attach it to their objection when they first respond to an unlawful detainer case. If it is an ARTLA or 2007 Act eviction, file it before your hearing or bring it with you to the hearing. It just needs to be in the record. We're seeing a really unsettling number of tenants representing themselves in eviction cases, and they'll file a pro se answer and they're arguing all of these things that show that they probably would be protected by this law if they were doing it correctly, but they're not doing the actual declaration or providing it to the court. So we're seeing these people, lose their homes when it does appear that they have a legal defense. And I would also recommend that every household member fill out a separate declaration and file that with the court. The order requires separate declarations for everyone. Okay. Last year, Congress passed the Coronavirus Aid, Relief, and Economic Security Act, otherwise known as the CARES Act. This is a very broad law. It has, over 4,000 sections. It did include a temporary eviction moratorium that expired back in July. So a lot of people think that the CARES Act is done, it's just dead, but it's not. It's many parts of it are still in effect. One part that is still in effect is a 30-day notice requirement for evictions for non-payment of rent. This only covers some properties. The CDC declaration covers pretty much all residential housing as long as it's not like a hotel, motel, some sort of short-term situation like that. But the CARES Act only covers properties that are funded by the federal government in some way. And I'm not sure what's happening with this pie chart, but anywhere from 26 to 46% of all rental housing in the United States is actually going to be covered by this, because it either has some kind of federal subsidy for the owner to provide income-based or affordable housing, or there's some sort of mortgage on the property that has been sold to the federal government in the form of Fannie Mae or Freddie Mac. You can look up multifamily properties to see if they're subject to the CARES Act at this database I've listed here. But if the property has 4 or fewer units, then it's not going to be listed there, and it's going to be much harder to determine that. An owner could look it up in some databases that Fannie Mae and Freddie Mac have provided on their websites. But for a tenant, especially a pro se tenant or someone representing themselves, that's basically going to be impossible. And at one point, the Arkansas Supreme Court had issued per curiam that required landlords to say in their eviction pleadings whether or not a property was covered by the CARES Act. However, it's my understanding that that requirement is no longer in effect. And you can raise fair housing or housing discrimination as a defense and a counterclaim. Jason, would you like to speak about this for a moment?
Sure. I will say that Legal Aid of Arkansas gives multiple CLEs on the Fair Housing Act, and if your local bar association wants one of those, we can certainly arrange that. We're doing one for Pulaski County on February 12th. But I'll talk a little bit about it here because it is very important to at least know the basics of housing discrimination law if you're dealing with any type of housing case. Fair Housing Act is a federal law that prohibits discrimination in any housing-related transaction, including landlord-tenant lease transactions, federally subsidized housing, really the gamut of housing law. What it does is it prohibits housing providers from treating tenants differently based on 7 protected classes. And so those you can think of as reasons that you can't treat people different from one another: their race, color, religion, national origin, gender or sex discrimination, familial status, which is discrimination against people with children under the age of 18, and then handicap discrimination or discrimination against the disabled. The Fair Housing Act is federal civil rights law. There's also a state Fair Housing Act as well that was enacted in 2001. The federal act was enacted in 1968, just right after the assassination of Martin Luther King. Kendall, you can go to the next slide. So what do we want to watch for under the Fair Housing Act? We want to, when we're dealing with eviction cases, and we want to kind of look at them for a fair housing issue, which is a very important thing to do. There are a few things you want to see. First is just obvious discriminatory conduct. So if you see some type of evidence that the eviction case is being taken or is being prosecuted for a discriminatory reason, meaning that the landlord is looking at the tenant, making a judgment about their race, color, national origin, religion, sex, or disability, and treating them differently, or evicting them, or subjecting them to unfavorable terms because of that, then that is a fair housing violation. You can bring that up as both an affirmative claim, which you can enforce as a counterclaim. For one, you can also enforce it as an affirmative claim in state or federal court for two, or you can make a complaint with the Department of Housing and Urban Development or the Arkansas Fair Housing Commission. Both of those agencies, obviously HUD's the federal agency, the commission is the state agency, and that will investigate those claims and enforce them through an administrative process. So you can do any of those things if you see the potential fair housing violation. So what are some fair housing violations that we see in eviction cases? First, we see issues with handicap issues and disability discrimination. So one of the things the Fair Housing Act allows is for tenants to make requests for reasonable accommodations and reasonable modifications. And an accommodation is a change in a rule or a policy that allows a tenant to use their unit more like an able-bodied person. A reasonable modification is very similar, but instead of a change to a rule or a policy, it's a physical change. So like a grab bars in the shower, or a wheelchair ramp, those types of things. And reasonable accommodations and modifications can be used in some cases to cure eviction or to stop evictions. For example, a very common example, if someone is being evicted for a violation of a no pets policy, but that animal is actually something that helps them with their disability. It's an assistance animal of some type, might be a seeing eye dog, might just be there for emotional support. Then they can actually get a reasonable accommodation from the landlord to not have that no pets policy as it applies to that particular tenant, which in that case, if they're being evicted for that, would then operate as an affirmative defense to the eviction. So that's just one example. We see stuff come up in domestic abuse situations. Gender is a protected class under the Fair Housing Act. So we see situations where people are being violated or being evicted in violation of the Fair Housing Act for being victims of domestic abuse. So maybe they have gotten an order of protection against an abusive spouse, and they're evicted because the police have been called to the apartment, or the landlord just found out about the order of protection. That has been held to be treating women differently from men, because women are overwhelmingly more likely to be able to use domestic abuse protections than men. There's also an Arkansas state law, 1816-112, that deals with victims of domestic abuse that I encourage everyone to take a look at as well if you have that type of fact pattern come up. The other type of fair housing case we see all too often are sexual harassment cases. This is where a landlord's engaging in sexual harassment against a tenant, or maybe an employee of a landlord, like a maintenance person. These are very common fact patterns, and take them very seriously if you hear about them. There are two types of sexual harassment under the Fair Housing Act. The first is a quid pro quo, which is an offer to exchange some type of sexual related favor for a housing related favor. So that would be your sex for rent type situation. And then there's also hostile environment, which is going to be unwelcome touching, unwelcome whistling, unwelcome comments, that type of stuff. If it's pervasive enough to create a sexually hostile environment, that will also rise to the level of a fair housing violation. All right, next. Oh, wait, go back one, Kendall. Fair housing and COVID-19. So specifically when dealing with the pandemic, there are a couple things you want to look at under the Fair Housing Act. First, COVID-19 is a disability under the Fair Housing Act. A disability under the Fair Housing Act is a physical or mental condition that substantially limits one or more major life activity. Breathing is definitely a major life activity, but even asymptomatic cases of COVID-19 limit a person's ability to interact with others and be in public, which is also a major life activity. So it's pretty undisputed that COVID-19 qualifies as a disability under the Fair Housing Act. What does that mean? That means people are entitled to ask for reasonable accommodations, reasonable modifications. People are not allowed to be evicted because they have COVID-19. So be aware for those types of issues. Someone who has an underlying medical condition that could be made worse by getting COVID-19 is also going to be considered disabled under the Fair Housing Act, and they can ask for reasonable accommodations. And we have actually used this to get people extra time when their lease was being terminated or they were facing eviction, by saying, look, if they are made homeless and are put out into the community, taken away from their home, it's going to put them at a higher risk of catching COVID-19, which because of their disability, whether that be diabetes or a heart condition or a lung condition, is going to put them in serious danger. So we've been able to get a lot of evictions delayed using reasonable accommodations for at least as long as the state of Arkansas is under a state of emergency, which it has been since March, and there's really no end in sight to that. Finally, we haven't seen this much, but I thought I'd put it in here. Race or national origin discrimination based on COVID-19 stereotypes is going to be a fair housing violation. So if you see discrimination against, Chinese people or other people of Asian descent, because landlords maybe think that they're more likely to have or carry COVID-19, that is going to be a fair housing violation as well.
Okay, thank you, Jason.
Yep.
Some other defenses that we see listed here, there's the unauthorized practice of law, which is both going to be a defense in a civil case. It's also a crime, although I've never seen it prosecuted locally, or in Arkansas, I mean. So this usually will come up when you have a business entity that is attempting to represent itself in court. And a non-lawyer cannot represent a business entity generally because that entity is like a separate legal person, right? And a non-lawyer cannot represent another in court. There is a narrow exception for this in small claims court where an officer might, an officer could represent a LLC or a corporation or something like that. So we see this frequently in cases brought under the Arkansas Residential Landlord Tenant Act. So if this comes up in a case, dismissal is required because, if someone files a lawsuit through the Unauthorized Practice of Law, that lawsuit is a nullity, like it never happened. So it is not something that can be corrected by amending the pleadings after someone has hired a lawyer. So that's something to be very mindful of, especially if you're advising landlords. I assume that most of us know about service and jurisdiction, but that can come up a lot, particularly in Art Law 2007 Act cases. If someone is served by posting, you may have grounds to challenge that. Waiver is going to come up in evictions sometimes. The way that might happen is if, the parties have a lease agreement where they make some promise, such as to pay rent on a certain day of the month, but through either another writing or just their course of performance, they've changed that by say, the lease says one thing, but the landlord always accepts rent in the middle of the month after the person gets their like SSI check or something. Then they could argue that, that provision has been waived. There is an opportunity to cure lease violations other than non-payment of rent under the Arkansas Residential Landlord Tenant Act, as Jason discussed earlier. So that's going to clearly apply to Art Law 2007 Act cases, and arguably it applies to unlawful detainer cases as well. This is not going to come up in a failure to vacate or criminal eviction because that can only be brought for non-payment of rent. So, and then if the owner receives any kind of federal housing subsidy, if they fail to provide the required notice or opportunity to be heard by that subsidy, then that would be a defense to the eviction as well. Where you might see this is, say, if the tenant lives in public housing or a similar arrangement and they are sued in an unlawful detainer case, but they haven't been given an informal hearing or an administrative hearing by the public housing authority before the case is brought to court. That would be a defense. There are some counterclaims that can be brought in eviction cases. Some are common, some are less common. Some of the more common ones are going to be fair housing or housing discrimination violations. In some cases, you may have an owner who engages in self-help eviction while the court case is pending for like an unlawful detainer. That would be a counterclaim. If the contract requires the landlord to make repairs and they fail to do so, especially if the tenant, then withholds rent because of those repairs, that could be a counterclaim. We have had some success in Central Arkansas arguing that city codes are implied into residential lease agreements. However, Arkansas does not have any statewide implied warranty of habitability. Government subsidized housing is going to raise due process concerns because those organizations that administer those subsidies are going to be state actors. So if they don't follow the right notice requirements or the right informal hearing requirements, they could be liable for a civil rights lawsuit for violating the tenant's right to procedural due process. The last two listed here are far less common, although they are interesting and worth considering. Property managers and attorneys who represent landlords can sometimes be considered debt collectors because they are collecting unpaid rent or debt on behalf of another, and therefore sometimes subject to the Fair Debt Collection Practices Act. You'll see in a lot of pleadings where landlords' attorneys will include what's called like a mini Miranda warning that debt collectors need to include on their communications. That's why that's a good practice. And we've also seen some interesting things around Deceptive Trade Practices Act work, although those are fairly uncommon. Counterclaims can be extremely useful for negotiating settlements. Some of those settlement terms might include the landlord dismissing the eviction case, the tenant dismissing any counterclaims they might have. Often the tenant will agree to move out voluntarily. They've either done so already or they're willing to do so at some point in the future. And the landlord will give the tenant a neutral reference, a true but neutral reference for renting in the future. And that can be extremely valuable for tenants because especially if they receive something like Section 8 or they want to apply for government housing in the future, and a recent eviction on their record probably impair their ability to do that. You can also, settle the debt or create an installment plan, address reasonable accommodations. You can do all sorts of things in those settlements. There are a lot of resources for people who want to do this work and for people who are working with tenants facing eviction in Arkansas. The Arkansas Fresh Start program is a wonderful resource. It's a new program here in Arkansas. It's statewide. It's a rental assistance program. Tenants apply online and they can receive rental assistance to catch up on back rent and avoid eviction. However, I understand that funding is attached to different parts of the state, and some parts of the state are out of funding right now. However, their website has a very comprehensive list of other places that provide rental assistance broken up, by county. So I would check that out and make sure that, tenants are looking everywhere that they can to get rental assistance. HUD has a resource locator at this website here where you can enter a city or an address and you can find low-income housing near you. I would recommend that a tenant do both of these before using the CDC declaration.
Point where we'll need to wrap up and start with questions.
Here's some information. And as Jason discussed earlier, the reason that we're doing this is because we're hoping that attorneys in private practice will join us in taking some of these cases. We're happy to provide more training, sometimes co-counsel if needed. However, the scale of the problem is very large. And if even a third of the attorneys here today would agree to take one case, I think that would make a tremendous difference across Arkansas. So, we appreciate you being here today. And if you are interested in doing pro bono in this area, you can contact me. You can contact Grenada Johnson at Legal Aid of Arkansas. I believe that Jordan is going to send out a survey, if he hasn't already, where you can sign up through that survey, and then we will follow up with you afterwards.
Thank you so much, Kendall and Jason. We've more poll for those folks who missed their opportunity to verify their attendance now or earlier. You can do that now. And while that poll is live, let's start working our way through the Q&A. One question that I saw that I want to make sure we get answered is, how do eviction notices need to be delivered? Can they be emailed? Can they be texted to a tenant? We had several questions.
So that Green v. Lindsay case, they can be given in any way that's reasonably calculated to get to the tenant. So I think if you've been communicating with the tenant through email throughout the tenancy, then you can probably email them an eviction notice. We see most of them being hand delivered or given, sometimes through a process server or someone else who delivers eviction notices. But it doesn't have to be that way. It can be any way that's reasonably calculated against the tenant.
There are a couple of counties with circuit court decisions, relatively old decisions, which say that sheriffs cannot serve notices in unlawful detainer cases. I might follow up with Jordan and put those resources online for you all. I believe that many of those are in Northwest Arkansas.
I'm not seeing their question now, but I know someone had asked if the CDC more to folks who are undocumented immigrants. Your
sound broke up a little bit, Jordan. Were you asking if the CDC moratorium applied to undocumented people?
Mm-hmm. Yes.
I'm not sure. I can confirm that and get back to you. I don't see any reason why it would not. However, those people may struggle to obtain government rental assistance, which they would need to apply for in order to be protected by the declaration. So that might kind of indirectly kick them out of that. Jason, do you know about that?
The CDC declaration only says they have to attempt to use best efforts to obtain government rental assistance. So if they try and they're not allowed to, I think they might be okay. I'm not aware that the CDC order addresses immigration status in any way whatsoever, so I don't think that there'd be any difference based on immigration status.
And this is a really important one that looks like something, but practically what can be done immediately for a tenant whose landlord changes the locks on them?
Step one would be to call the police. Say you are the victim of an illegal lockout. Some police departments are well versed in the law and will help tenants with that. We've seen numerous cases where police knock off the locks in that type of situation. Sometimes they don't, and in that case, you would need to call legal aid or another attorney, and you're going to have to go to court and get a temporary restraining order to get back into the property.
Okay. Is asking if there are rights for cohabitators who are not named on the lease. How are they treated in holdover or under the moratorium?
Typically, if the person who is on the lease gets evicted, then their guests are not going to have any right to be there either, and are probably going to become trespassers and can be removed that way.
I would want to know how long the person has lived there and if the landlord has been aware that they've lived there for quite some time, because if so, that person might have transformed from like a guest or an unauthorized occupant to a tenant, and then they would have the legal protections of a tenant.
That is true. The other thing is that most unlawful detainer cases are going to name both the tenant that's on the lease and any and then any occupants of the property as well. And Writ of Possession will have that on there too. So that usually authorizes the police or the sheriff to throw out anybody who might be there.
The poll, again, if you're an attorney attending and you want to claim CLE credit and you haven't responded to one of the polls, please go ahead and respond to that. And let's see, someone has a question. Suppose the unlawful detainer summons doesn't mention the 5-day requirement. What result?
Well, that would be in the discretion of the judge in that case, but I don't think that that requirement can be enforced if the tenant isn't served and notified that it exists. If they try to file just a normal answer within 30 days, I think that that should be sufficient in that situation.
Okay, and then I'm going to summarize this one because it's long and we've just got a few more minutes to answer questions. It's basically what can be done if the clerk fails or refuses to issue a writ of possession after someone has given notice, summons has been issued, and complaint has been filed with the affidavit.
You have to take that up with the clerk.
And that was a commercial lease agreement, it looks like they followed up to say.
You could also make a motion to the judge.
And then someone asked how all of this applies to lodging, let's see, it looks like short-term rentals.
So short-term rentals are a tricky situation because they kind of fall in between traditional lodging agreements, like if you're staying at the Holiday Inn for a night, and an actual rental. It's going to depend on what the contract looks like that you sign to live there. I mean, most of your short-term rentals are going to be lodging agreements and are not going to be covered by landlord-tenant law. But if you're staying there for multiple months and paying rent, then yeah, that can be construed as a tenancy for sure.
And then Dylan had a question, does the Fair Housing Act use the same analysis as the Americans with Disabilities Act?
Or, I mean, not exactly would be my answer to that. There are some differences there. It's the same, I guess, general analysis, but there are they're different laws and they are interpreted a bit differently.
Okay, and we'll take just a brief second to pause. The poll has closed now, and we asked criminal eviction. 81% of folks said 1. Sadly, Arkansas has the distinction of being the only state in the country with a criminal eviction statute. And we also asked what's the only state in the country that doesn't guarantee minimum habitability standards for rental units, and that's also Arkansas. And let's continue. It looks like we've got 4 more minutes. If you've got 4 more minutes to stick with us, we'll answer as many questions as we can. To prohibit guests who have a previous theft felony conviction.
Do you mean like, is that person, would the tenant then be subject to eviction?
I think that's what John's getting at, is what can a landlord limit as far as guests in the property?
Well, I'm thinking through this for a moment. It would depend on what is in the party's lease agreement. There are restrictions on like discrimination based on criminal background. However, if the parties don't have anything in their lease agreement and someone just has a guest come over one day who happens to have a felony, I don't see why that would be, how that could be grounds for eviction unless that person engages in a crime at the property. You know, tenants can bring guests of their choosing over generally.
And it looks like someone's asking about CLE forms. That's an important point. You've got to stick with us for 2 more minutes to make sure you get credit, but those are available at arkansasjustice.org/eviction. A few folks have reported that switching your browser or clearing your cache, and you should be able to access the documents. But again, arkansasjustice.org/eviction is where you get the CLE forms. Frank asks, how does filing bankruptcy affect an eviction?
In an eviction for non-payment of rent, an automatic stay would go into effect in the eviction case. They could be evicted on other grounds, though.
I don't see that.
Dana asks, so for a client who lost income due to COVID but does not live in a covered property, there's no relief under.
Well, so the tenant has to be a covered tenant. I mean, a covered property was more a thing under the CARES Act. And that's still an important thing to look at because it may be that they're entitled to a 30-day notice instead of a 3-day notice for non-payment of rent. But if they're in any type of landlord-tenant situation and they're being evicted for non-payment of rent, and the CDC declaration applies to them, meaning they meet all those criteria in the CDC declaration, then they can be, and they sign that and give it to their landlord, then they're going to be a covered person under the CDC order.
Okay, it looks like we're right at time. So if you're an attorney and you were waiting an hour and a half, you've met that now. If Kendall and Jason have a few minutes, we'll continue working through questions for a few more minutes. Dylan had a follow-up to his question earlier about the framework on the Fair Housing Act versus the FHA. And he says he's clarifying for reasonable accommodation. Is it the same framework?
I'm not an ADA attorney. I will say the framework for reasonable accommodation under the Fair Housing Act is if the accommodation is necessary and reasonable, then the landlord has to grant the accommodation. It is necessary if the tenant can show that, one, they have a disability under the definition of the Fair Housing Act, and two, that there is a nexus between the disability and their requested accommodation. At that point, the landlord can attack the reasonableness of the accommodation by showing it's going to cause an undue financial or administrative burden, or it's going to be a fundamental alteration in services provided. So that's the analysis for any reasonable accommodation request. I will say the animal analysis under the Fair Housing Act is a little bit different because, unlike the ADA, the Fair Housing Act does not parse service animals and emotional support animals apart and treat them differently. They're all treated the same, called assistance animals under the Fair Housing Act, and they are both going to be, or assistance animals are going to be a valid, reasonable accommodation, and as long as there's that nexus there.
We'll just do a couple more and then we're going to wrap up. Again, I've had several people ask about materials or forms. All the materials and CLE forms are at arkansasjustice.org/eviction. And the evaluation for this program, and as a pro bono attorney, that will pop up when this webinar closes. You'll be able to answer those questions there. Howard asks, if a landlord abandons the damages hearing and does not seek judgment, what is the time period that the tenant's possessions are considered abandoned?
If the landlord doesn't seek possession?
Yeah, I think the question was getting at just how long before the tenant's possessions are considered abandoned.
I mean, abandonment in general, if there's not been a court case, is just going to be based on reasonableness factors. So if the landlord goes by and it looks like the tenant has moved out and there's no power on and there's no car in the driveway and it looks like they've mostly moved out, then they can consider it abandoned. You know, if they know that the tenant goes to work every day at 8 o'clock and they come over there at 9 o'clock and say, oh, gee, the tenant's not here, even though all their stuff's there and the power's on and they paid rent, you know, then that's not going to be considered abandoned. So, I mean, you're going to look at, one, whether the tenant is paying rent, but also just reasonably, is the tenant there and are they intending to come back?
All right, well, thank you again. Oh, sorry, go ahead. Go ahead, Ken.
I was just going to say that if the landlord has been holding it in storage because they're required to do so under the Unlawful Detainer Act, I don't think that's a situation where you can fairly argue that they've abandoned it. Usually in unlawful detainer cases, after there's an initial decision on possession, who gets to keep the unit, the parties will come to some kind of agreement about the property and the tenant can come get it at a later date. But
yeah, I would think if the landlord dismisses their case and does not pursue a money judgment, then they don't have any basis to hold that property anymore and need to give it back.
Well, I want to say thank you again to Jason Auer at Legal Aid of Arkansas and Kendall Llewellyn with the Center for Arkansas Legal Services. Also, Professor Lynn Foster helped with this, and John Comstock and many others who you don't see on your screen today. We appreciate everyone who helped out. Thank you so much for attending. A recording of this will be up shortly this afternoon at arkansasjustice.org/eviction. And don't forget to fill out the survey when you close out Zoom today. Thank you so much. Have a good day, everybody. Bye-bye.
Thank you.